The House is at the 11th order and will have under consideration House Bill number 100. Good lady from District 28.
Thank you, Mr. Speaker. Mr. Speaker, I ask unanimous consent to dispense with further reading of House Bill 100.
You heard the unanimous consent request. Is there an objection? Hearing none, the lady has the floor to open the debate.
Thank you. Mr. Speaker, the purpose of this legislation is to remove a disparity in calculations in PERSI calculations for part-time elected officials. Idaho statute governs the PERSI benefits that are eventually paid to a part-time elected official, like a mayor or a commissioner, who also has been elected or appointed to full-time government service at some point in their career. A split calculation considers both the part-time and full-time portions of service in determining the retirement benefit for most, but not all, elected officials. In 1990, new legislation created a different calculation for legislators, allowing all of their years of service to be calculated as full-time, creating a dramatic spike to those pension payouts. No other elected official can claim this same calculation or advantage. And if I may, I would like to turn some time over to the good gentleman from 21 to share an example of how that calculation
Will the gentleman yield?
The gentleman yields.
The gentleman has the floor to continue the opening debate.
Thank you. Good Speaker. You do have a handout on your desk that looks at this little spreadsheet we put together. So here's a case of some folks. First of all, you know we all put into PERSI at the same rate. State puts in 11%, and the employee puts in about 7% more. So we all put in this at the same rate. And I have a situation here where we have a part-time, let's say Mayor Max, earning $16,800 a year. And he works for 30 years as a public employee. The last 42 months, maybe as a full-time appointment to some department. At $102,000 a year, in my example here at least. So Mayor Max, as we go through the PERSI calculation of what he's contributed during his time as a mayor, the split calculation takes into consideration those many years of part-time service, and then takes into consideration those years or months of full-time service. And so at the end, in this split calculation we've heard about, Mayor Max would receive $1,800 a month as his retirement benefit. Now, Representative Steve did the exact same thing. He worked 30 years, the first many years as a representative, making $16,800. And for the last 42 months, he also was appointed to a nice high-paying job with the Department of Agriculture at $102,000 a year. Not qualified, but hey, I took it. Representative Steve has a pension of $5,100 per month after retirement. Both Mayor Max and Representative Steve contributed the same amount, month by month, year by year, into PERSI. That same 6.79, the same 11.23, in it went. In fact, we'll notice that both Mayor Max and Rep. Steve had contributed over those 30 years $145,000 to the PERSI account. Both identical. And yet, Rep. Steve will take home nearly 3 times as much in retirement than Mayor Max will. This is the pension spiking that we're talking about that we desire to remove and put us, the 105 of us, on the same footing as the statute would have if we hadn't been carved out explicitly by name. For fun, I put in Representative Kelly, who spent 30 years as a representative, put her 6.79% in, and the state matched it. I did not receive the last 42 months, last 3.5 years, at the higher rate. Her take-home in retirement will be $840, which is 1/6 of the amount that Rep. Steve takes at the $5,100. This, in a nutshell, is how the split calculation works and how that specific carve-out benefits, in a dramatic way, the 105 of us. This came out of our committee unanimously with a do pass recommendation. And either one of us would be happy to stand for questions.
Is there further debate? Gentleman from 6.
Thank you, Mr. Speaker. Would the good gentleman yield?
Will the gentleman yield to a question?
He yields.
Gentleman yields.
Thank you, Mr. Speaker and good gentleman. I know in private industry that oftentimes the last 3 years or 42 months are used to calculate the pension benefit. In those plans that still retain a defined benefit plan. So the proposal in this bill is to not mimic that at all, or is it just that you consider that legislators are considered part-time rather than full-time employees, which seems to me to have a whole new set of issues?
Gentleman from 21.
Thank you, good Chairman, good Representative. This bill, if you look through the bill, doesn't change the definition at all of what constitutes a full-time or part-time employee. So that piece of it becomes irrelevant. Percy has its own way of determining, I suppose, how they classify us. There is a definition in this section that does describe the part-time employee. In that same section, it carves us out explicitly, which makes the implication that we're included in that set. From Percy's point of view, we are included in that set. The situation is for an elected or an appointed official of the state. This is already in statute. We're not changing this need for a split calculation to provide an appropriate Percy benefit. Again, the mayor example that I gave in the handout is per statute. It's not changing or creating some new thing in that condition. I suppose the idea was, many years ago, was that we know there's full-time employees who will grow in their career over their time, and as is typical in the corporate world as well as here, we would take the last 42 months, and that would be what their pension is based on, or whatever number is agreed to by the board. Also, it appeared needful back in the day when this was initially written that there would be an appropriate split calculation for those part-time elected or appointed officials who also had some full-time components. We were in that category all along until 1990 when we were explicitly carved out of that already existing calculation. I might also note, since you bring this up, that the calculation still, as in statute, even for Mayor Max, favors the full-time component. By the calculation, every year of full-time service adds another year of full-time service, and it deducts a year of part-time service. So that at the point where the full-time service equals the part-time service, the entire split goes away, and the whole thing is calculated as though it was all full-time. This gives a nice benefit still, even to Mayor Max in this situation. So as the months and years progress, the part-time portion in the calculation is whittled away until it equals, and at that point it is entirely goes to zero, and all of it is considered full-time. Thank you.
Gentleman from 6.
Thank you, Mr. Speaker and good gentleman.
Gentleman from 9.
Mr. Speaker, question would the good gentleman stand for a question?
Will the gentleman yield to another question?
He will.
Gentleman yields.
Mr. Speaker, so it looks like the intent of this legislation is to keep people from working part-time for a while and then at the end going to a good paying job and receiving full-time benefits for the whole thing. But it looks like, reading the legislation, that this bill will apply to all legislators whether or not they go on to a full-time job, so that the people that are here and on the other side of the rotunda will all just receive, for example, 3 or 4 months of Percy accruals of service as we go through here. Is that correct? Does this apply to all of us, even if we don't go on?
Gentleman from 21.
Thank you, good Speaker. You made a comment and the question.
But
And
you're
now I've
just going
forgotten
to
your
answer
comment.
the question.
But we'll work on the answer to the question. This does apply to all of us, 105 of us currently sitting. This isn't changing anything per se, as you're implying, that's in statute that would normally be applicable to a part-time appointed or elected official. So that's already in statute. You mentioned a token-type payment for folks like us, and that's not the case. So folks like us, or folks like a mayor or a city council member who might fall in this category, will receive their full pension just as we will. They put in their 6.79%, the state puts in their 11.23, it grows at a certain rate, it's times by 0.02, it's multiplied by the number of months of service, divided by the number of years, and so on. And the calculation comes out the same for any of us that have put into it, just as it comes out for any state employee who also puts in. So the state employee and us, let's pick on Representative Kelly in my example, who was 30 years in government service as a representative. She will follow the exact same calculation as the Director of Health and Welfare will. They will look at the months of service, the high 42, times 0.02, times number of months, and get their monthly pension. So on this chart, for example, that comes out to $840. If I spend 30 years at my current rate, that's my properly earned and deserved amount. And the same is true for Mayor Max, who's also put in those at the same time, also had a higher paying job. Because he had a higher paying job, certainly he was putting in a higher contribution at his 6.79%. So of course he'll have higher in the end. Plus, don't forget that he was also counting 2 years per one as he was employed full-time. The difference here is that Rep. Steve has also put in the same amount and should receive the $1,800 as Mayor Max did. But we don't. In this current statute, it calls out legislators explicitly to be pulled out of this split calculation affecting the 105 of us. What this does simply is it removes that explicit carve-out and puts it on the same footing as the statute is currently for all other appointed or elected officials.
Mr. Speaker, another question.
Will the gentleman yield to another question?
He will.
Gentleman yields.
Mr. Speaker, this has an effective date of July 1st, 2015. So my question would be, what would happen to representatives who have, for example, served 12 years already, and then they retire in some future time? Will they lose? Right now, they would think that they would have 12 years times 12 months or 144 months of service accrued. Do they now have something less than that?
Gentleman from 21.
Thank you, Speaker, and Representative from number 9. This changes no other PERSI rules, and so they would have accrued service as any other employee would. This changes no PERSI calculation rules, other than the split calculation applying to representatives.
Gentleman from 9.
Okay, Mr. Chairman, I'd like to debate against the bill.
Gentleman has the floor.
Mr. Chairman, I should say that I'll never have to be concerned about the Rule of 38 because I've already retired in PERSI. Couple things. One, in our freshman orientation, they suggested to us that we write bills that have a very wide general application, not bills that affect 1 or 2 or 3 people. And it looks to me like this bill will only affect a few people per decade. And it looks to me like we're affecting a lot of people and we're only trying to affect a few people. Secondly, Mr. Speaker, good ladies and gentlemen, the people who serve here and who serve on the other side of the rotunda form as a group a solid body of well-prepared individuals who potentially can fill some very important elected or appointed positions here in Idaho. I believe that the passage of this bill reduces the likelihood that these good ladies and gentlemen will be interested in filling those positions, thus hurting Idaho as we move forward with not as good a quality of people filling those positions. I also look at the young people who are in this body. We need a good balance of different types of careers, different ages in this body. And I've talked to some of the young folks here who are already thinking about this is going to be pretty tough on their careers to even stay here. We reduce their benefits. We reduce the possibility of them having a good nest egg at the end of their careers by doing something like this. I think it's going to hurt the quality of what and the balance of what we have in here. Mr. Speaker, one last point. any time we're doing any part-time, it looks like, based on page 2 of this bill, that these folks are going to fall under the normal part-time for the rest of the state of Idaho, the commissioners and city officials and so forth. So if they're going to do that, I think the calculations are going to be fairly difficult for legislators. We're here for a while. We serve on interim committees. We do constituent services. We spend lots of time researching our bills. And many people in this body put in nearly close to a full-time work, or at least half-time. And so I think that I understand the thinking behind this bill, but I think it's a real bad bill. Please join me in giving it the red light.
Is there further debate? Gentleman from District 24.
Thank you, Mr. Speaker. Would the good gentleman from 21 yield to a question?
Will the gentleman yield to a question?
He yields.
Gentleman
Thank you,
yields.
Mr. Speaker. Good gentleman, within the last day or two, there's been an Attorney General's opinion on this topic that suggests that this issue might well be handled by the Citizens Committee that deals with legislative pay. Are you familiar with that opinion, and what is your reaction to that opinion?
Gentleman from 21.
Thank you, Chairman, and for that question as well. I actually have 4 different AG opinions, including the more recent one that you're referring to. And I was very pleased to see the positive response to our bill in the AG opinion. The AG opinion was clear that this body has the authority to work in this manner, and that we are appropriate moving forward.
Gentleman from 24.
Follow up, Mr.
Will the gentleman yield to another question?
He yields.
Gentleman yields.
Thank you, Mr. Speaker. Good gentleman, the letter also suggests that there may be a legitimate constitutional challenge from a couple of different fronts on this matter. One is that it appears to maybe be in violation of the clause of the Constitution that says that legislators should not affect their own pay during their term of office. And since this is a benefit that affects people who are currently here, that there would be a constitutional question. What is your response to that point?
Gentleman from 21.
Thank you, Mr. Speaker. That was the explicit point requested of the Attorney General. And if I may read it.
Without objection, the gentleman may read.
I apologize for my poor reading skills of this legal stuff. Based upon the above, and that is the 6-page discussion on this very point, the most conservative legal counsel that can be offered is that the legislator possesses the authority to adopt House Bill 100. Let me continue. But the legislation will likely require approval, which could be as simple as, in quotes, maintaining the benefits as provided by statute, which might be a common phrase used by that committee, by the Citizens Committee, and subsequent acceptance by the 2017 legislature. Equally, however, the court may review House Bill 100 to determine that service accrual has no monetary value. The Citizens Committee has no oversight in the effective date of July 1st, 2015. And so it seems simple enough that if the committee believes itself to have authority in this manner, they would state so simply by allowing or perhaps disallowing the recommendations of this bill, the recommendations of this bill, or equally likely, the courts would argue that there's no bearing here since this does not affect the monetary compensation during our 2-year term.
Gentleman from 24.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor.
Thank you, Mr. Speaker. It seems to me that there are enough questions raised in this Attorney General's opinion, and it's not the only opinion on this topic that's been sought over the last several years, to raise some substantial questions as to whether, one, this is a defensible bill to pass from a legal perspective and a constitutionality perspective. And I also think that the good gentleman who raised the question about the pool of individuals, particularly younger representatives, and how that pool of people, which often forms a necessary part of the administration of state government, is very likely to be reduced by the passage of this particular legislation. So I'd ask our body to think about those issues as they consider their votes on this matter. Thank you, Mr. Speaker.
Thank you, good gentleman. Is there further debate? Gentleman from 24.
Thank you, Mr. Speaker. Debate against. A
Gentleman
couple
has
of
the floor.
comments on this. And one, I don't know if I should declare Rule of 38. I've got 20 years of combinations of full and part-time, depending on someone's definition as a
We'll
elected
note
official.
that declaration, anyway.
Yeah, I understand. Part of the reasons that I want to make that clear is that the bill, and not necessarily this little amendment, but the bill implies that legislators are part-time by definition. And I'm not sure how many of you have turned in your worksheet this week to show how many hours of work you put in, or last week or last August. All we have to do is average 20 hours to be classified as full-time. In my background, I've spent many hours as a city council member and as a mayor that I believe would fall under the lines of Max on our sheet here. Max is making $1,400 a month, is considered part-time, meaning he's making, if he's working 19 hours a week, he's making about $17 an hour as the mayor of whatever community Max represents. But I can point out to you there are many mayors that worked a lot more hours as a mayor as I did during the 6 years I served as mayor, that probably are putting in 40, 50 hours a week, maybe only making $800. When I contacted Percy over this matter, and keep in mind, I understand this bill is trying to make it that the legislators are the ones that fall into this other category, but the question is are we full-time or are we part-time? But when I contacted them, I asked them to tell me which years I worked part-time and which years I worked full-time. And they're not able to answer that. The answer was, depends on what your salary was. So if I had what they classified as a small salary, I was classified as part-time. If I had a large salary, I was classified as full-time, or over 20 hours. And that's really the definition. The problem I have with this is I know that many people in this room have put in many hours as committee chairman, maybe more, leadership, even beyond that, this makes the presumption that they are all part-time, and that we would have to prove our hours. And if you've been in one of those roles for the last 10 years, 2 years, 15 years, if you haven't been keeping track of your hours, you may not be able to argue with Percy whether or not you were full or part-time. And while I commend the idea of trying to level the playing field, this entire section of statute is unfair to Max. I would urge you to vote against this. Thank you.
Is there further debate? Gentleman from 28.
Thank you, Mr. Speaker. I would remind us that, and Mr. Speaker, that when we campaign that we want to come here and be of service to the people. If we come here and have an eye on the compensation and the retirement, I think we're here for the wrong purpose, and probably we should step down and be replaced. There are plenty of people that are out there that want to replace us, so I would support the bill and encourage you to do the same for that reason. Thank you.
Is there further debate? Gentleman from 20.
Thank you, Mr. Speaker. I don't want to debate the bill necessarily, but I do want to share this with you. So in 1890, March 3rd, 1890, we signed the Constitution of Idaho. And if you look in Article 3, Section 23, it states, compensation of members. The legislature shall have no authority to establish the rate of its compensation and expenses by law. That's our Constitution. Thank you.
Is there further debate? Gentleman from 27.
Thank you, Mr. Speaker. To debate against the bill.
Gentleman has the floor.
Thank you, Mr. Speaker. Mr. Speaker, just to make sure that everyone understands my philosophy so that at a later point in time, somebody doesn't try to take anybody to the woodshed. I think the point of this bill is to try to take away what is perceived as a privilege that the legislature has that other citizens in the state do not enjoy. I concur with that. But we have several privileges that I think that we enjoy that I think the Citizens Committee should take away. As a matter of fact, the good gentleman from 22 and I tried to do that this year, and were directed to the Constitution. So I'm going to go over those briefly. The first is per diem. The per diem, I think, is unfair. I get the fact that it's based on the federal model of per diem, but some people are taxed on it, some people are not taxed on it, based upon where you live, etc. The next is, and this particularly grates on me, is health care benefits. We sit on the absolute finest health care benefits that you can purchase in the state of Idaho, all paid for by the taxpayers, Mr. Speaker. Thank you very much to the citizens of Idaho for providing me that, even though I'm Medicare eligible and don't really need it. And we have a whole bunch of people in the state who have no health care benefits at all. Thirdly, are the removal of retirement benefits in general. I don't think the legislature should enjoy retirement benefits of any kind, period. And I do think that the Citizens Committee, and I hope they're listening to this debate, and if it changes 2 years from now, they can pull up the archives and listen to this debate. But the constituent services bonus that we get at the end of every session, which is about $1,800, needs to not be fixed, because if you look at legislative districts 7, 8, 32, and others, they need a whole lot more in terms of reimbursement for constituent services than legislative districts such as 15, 16, 17, or 18. So I would encourage the Citizens Committee to look at all of this and end all of those special privileges for the legislature, because we don't need them and we shouldn't have them if the citizens of Idaho don't. Next, Mr. Speaker, and the good gentleman just before me brought this up, but I'll read it again. Now, you know, Mr. Speaker, you and I both joke about the dialect of English that's spoken up Goose Creek, okay? And the implication, as you and I both know, is that it's just plain spoken English and it means exactly what it says. And as a matter of fact, there are bills going before the United States Supreme Court today, or at least in the next month or two, and the whole issue is going to be about the plain reading of statutes and the plain reading of the Constitution. Mr. Speaker, Article 3, Section 23 of the Constitution says, and I shall read it again, compensation of members. The legislature shall have no authority to establish the rate of its compensation and expenses by law. Now, the plain reading of that is that we have absolutely no authority to be monkeying around in what we are monkeying around in today, in my opinion. Let's take this as an example. As I read this, let's presume for a moment that the executive branch of the legislature found itself in need of a director of the Department of Health and Welfare. And let's presume for a moment that I lost all of my mental faculties and agreed to do that, which I would never do, but let's just presume so, okay? Well, Mr. Speaker, if I read this correctly, what that means is that if I went and did that job in June of this year, my rate of compensation would be significantly different than if I went and did it in July of this year. That is wrong. This body is changing my rate of compensation in the middle of my term, and we have absolutely no authority to do that. In closing, Mr. Speaker, back in the early 70s when the legislature proposed this constitutional amendment, that was a pretty wise legislature, because what that legislature said is the legislature should not be involved in its own compensation, and it should be up to the citizens of the state of Idaho to do this. And I think we should continue that practice, and the legislature is ill-advised to get involved in this, and so I will be voting no. Thank you, Mr. Speaker.
Thank you, good gentleman. Is there further debate? Hearing none, the lady from District 28, please stand and close the debate.
Thank you, Mr. Speaker. I appreciate the debate that's happened here today. I love the fact that we can engage in this, and I think that's a very important part of this process. I would like to speak to a few of the things that have been talked about this morning. First is the sacrifice that we all make to be here, and I agree. I live that every day and enjoy it, but I also enjoy the privilege and honor of serving in this great body, serving with great members, and being a part of this system, and appreciating and participating in many wonderful experiences that others don't get. Yes, it's a sacrifice to be here, but I didn't choose to be here because I thought I might get a better retirement pension than somebody else. I didn't even know about that when I came and decided to run. Part-time, the part-time status, that already exists in statute. We're not changing that, we're not amending that, we're not deciding if that's how we should be perceived or not. If somebody in this body would like to take that up, I welcome that discussion, but that is not what we are doing here, nor would I ever be one that would decide whether we should change that definition for us. To speak to the question about whether the 12 years and 12 months would all be accounted for, yes, they will. All time served is still accounted for. In fact, my 5 years as a city council member in McCammon, Idaho, which was very part-time and a very small amount, is still accounted for and will stay in place regardless of what we do here with House Bill 100. There are various AG opinions on this, but regardless of those, there's been a precedent set, and I'm asking us to right a wrong that happened in the 90s. In the 1980s, a good gentleman from across the rotunda in the other body actually carved this back out one other time. And unfortunately, another gentleman from across the rotunda in that body there actually put it back in the 90s. So precedence has been set whether we like it or not, and I'm asking us to right the wrong and take it back out. Because you're right, Article 3 does state that we should not participate in that discussion, and so I don't think it should have happened in the 90s. And speaking specifically about Article 3 in our Constitution, that's what the AG opinion that we just received yesterday specifically addressed, and I would ask for your green light. Thank you.
Thank you, good lady. The debate is closed. The question before the House is, shall House Bill number 100 pass? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Representative, does any member wish to change his vote? Clerk will lock the machine and record the vote. The roll call shows 38 aye with 32 nay. House Bill 100 has passed the House and will be transmitted to the Senate.